This is Law with Charlie, hosted by Charlie Medcalf. This is your podcast and YouTube channel for all things law, legal academia, and qualifying as a barrister.
Hello and welcome to this next episode of Law with Charlie, the podcast with me, Charlie Medcalf, and it's great to be with you once again. And in this episode, I'm going to be doing my Law of Evidence and Revision podcast introduction episode thing. And so if you haven't heard my previous episodes, which are like this is just going to be an overview of the topic of the law of evidence so that I can provide it in a podcast format for revision purposes. This is because I quite like listening to podcasts, and there's some really good podcasts out there actually, and I like to listen to these podcasts when I'm doing more of the mundane things, so cooking, washing up, laundry, etc., or even just walking. And it's a way to expose me to the knowledge I need to know. And for me, it does work. So I'm very much doing these episodes for myself, but also for many other people out there as well. And so I do hope that you find this as useful as I will. Also, if you haven't already, please do check my YouTube channel, Law with Charlie, where many videos which will be touching on the same content will be available as well. The videos essentially go into more detail in lecture format, whereas this podcast is more revision format, and there will be other bits of my content where the podcast will go into more detail, and the YouTube videos are more of a summary. So please do check out there as well. I'm not going to bore you with the introductory components much longer. I'm going to go straight into the overview of the module, this topic of the law of evidence, and go to the first topic, which is the burden and standard of proof. And this might sound simple, but actually, although the first part of this area is reasonably simple, it gets a bit more challenging as you go further through this topic. And so, yes, you will be looking at who bears the burden of proof and the standard of proof, and you'll be looking at what the different standards are for both the burden and the standard of proof, both in criminal trials and civil trials. However, you will learn that there are exceptions, and that sometimes there's reverse onus clauses, so where the burden of proof may be on the defendant rather than the prosecution, for instance. And you will look at when that is the case, why that is the case, and the exceptions when the legal burden / evidential burden can or cannot be placed on the defendant, on the defence. Once we've looked at burden and standards of proof, which is very much a foundational topic, without this you can't really go any deeper into the fascinating world of evidence, we go into the second topic, which is on confessions and inferences from silence. And this area is very much like the burden and standard of proof area as well. We will be learning about the general rules, so how essentially confessions and inferences from silence are not really allowed in to the trials, but then we will learn about the various exceptions, to which there are many exceptions. And so when can we draw inferences from silence, and what inferences are they? When can we admit a confession into evidence, and if we are able to admit a confession in evidence, is that always going to be valid in evidence, or can it be excluded in any way? Then once we've done that topic number 2, arguably one of my favourite topics in the law of evidence, and if you're looking for a legal career, this is very much the topic of most relevance for you. This is the topic of questioning of witnesses and special measures for vulnerable and intimidated witnesses. And so this is really divided into 2 sections. The first section of this topic is questioning techniques, where you will learn about the law around examination in chief and cross-examination and re-examination. What questions can you ask? What questions can't you ask? Are micro and some useful exceptions which not many people know. And essentially that's just the law around the questioning style and examining witnesses. We would also be looking at when we can declare a witness as hostile. What does that mean for both the witness, the counsel, i.e. the barristers, and the case? And also, what if the witnesses have forgotten some details? Are they allowed to refresh their memory, for instance? Once we've done all of that stuff, we then go on to additional support available for witnesses. I say additional because although the memory tasks are also very relevant, we go on to the areas of special measures for vulnerable and intimidated witnesses. And so there's different measures for vulnerable witnesses and different measures for intimidated witnesses, and it depends therefore whether you're a vulnerable or intimidated witness, whether you're an adult or child, and it also very much depends on the type of case as well. So we will look at, to begin with, generally with the various special measures which can be made for both vulnerable and intimidated witnesses, as well as the various special measures which can be made for the defendant, which are extremely limited compared to that for witnesses. And then we will also look in a bit of detail at special measures available for witnesses and particularly victims of sexual offences, because there is a special load of special measures and provisions which are relevant to those trials which do concern sexual offences. Once we have done the questioning, we then move on to the evidence of character, where we look at both good character and bad character in both criminal and civil contexts, and the various exceptions. And we will have a particularly heavy focus on bad character evidence, and like other areas in this course, we'll look at the general rules around these areas of evidence before then looking at the various exceptions. And so bad character evidence, for instance, is prima facie, on the face of it, unlawful unless any of the exceptions apply. And so we will be looking and analysing those different exceptions in some detail so you're able to apply the law to both exam questions and even in practice as well. Then, once we have covered evidence of character, we get into maybe more of the practical kinds of evidence, the evidence which the police officers collect, or the evidence which can form part of the case to actually prove whether an offence has happened. So in the course so far, we would have covered the burden and standards of proof, we would have covered confessions and inferences from silence, which is very much to do with how the defendant behaved and their conduct, the questioning, then evidence of character, which only applies to previous offences. We then get into the areas which help the prosecution in criminal cases, for instance, to prove the offence. And we begin with the law around identification evidence. And so, again, we will look at the various different types of identification evidence, so the difference between formal identification procedures and informal identification procedures, the difference between eyewitness evidence and recognition evidence in controlled versus uncontrolled situations, and the various rules which apply to that evidence around admissibility in particular, and the guidelines which the police must follow in order for identification evidence to be lawful and fair for the defendant. We also evaluate different types of identification evidence and look at the protections for the defendant in the court as well. including the various exclusions and the Turnbull directions from the case of Turnbull, which is very much a central case for this area of the law of evidence. Then, once we've covered identification evidence, we go on to yet another fascinating area, and this one is a big one. This is hearsay evidence. So this is basically out of court statements, and we start by looking at the general rule where essentially hearsay evidence is not admissible in criminal trials. But then, as you have probably noticed in both this module of the law of evidence and in the law more generally, there's always exceptions to the rules. And so once we've looked at how hearsay evidence is unlawful, we will look at the various exceptions when hearsay evidence can actually be lawful. So when can we allow hearsay evidence into a criminal trial without it impacting on the prosecution's case, for instance? So that's again another way where we can prove the actual offence in question, although this is also very much linked to the questioning of witnesses. And there's many synoptic links to the law of hearsay evidence as well. Hearsay evidence, like so many different areas of this course, can link in to all different areas. So yeah, if you're in a court, you might notice how all these areas of the law of evidence are coming up at the same time. That's because there's not really a linear progression of these laws, because they can all happen at the same time, such as is the nature with evidence. Then, once we have covered hearsay evidence, we then go on to expert evidence, and we should know that expert evidence is quite different from other types of evidence, as in experts don't necessarily tell us what they have seen in terms of what the crime was. They didn't see someone stab someone else, for instance, but they are providing expert testimony over other parts of the evidence. So that could be blood analysis, shoe prints, they could be experts in looking at photographs using various techniques, DNA testing, etc. And so essentially experts' duties are to the courts in order to help establish facts and provide their expert opinion. And that is the vital bit. When we're questioning experts are entitled to provide their opinion, and they're essentially the only witnesses in cases, particularly criminal cases, which are allowed to provide their own opinion, their professional opinion. And so we'll be looking at the limits of the law around that area, as well as the general admissibility of expert evidence. Finally, once we have looked at expert evidence, we go on to the final topic, which isn't necessarily an area of a type of evidence, for instance, but is again another really important topic which really pulls all of these different areas of evidence, the law of evidence, together, and areas which you should look at throughout any essay questions, exam questions on the law of evidence. And this is illegally and improperly obtained evidence. So you can probably imagine how this is essentially any evidence which we've already discovered, which has been collected improperly or even illegally. And we will look at how illegally and improperly obtained evidence can lead to miscarriages of justice, confessions, and how they are problematic and lead to miscarriages of justice. For instance, the Birmingham Six and so on, as well as honey traps. I think it's Colin Stagg from Wimbledon, who was victim of a honey trap which led to a miscarriage of justice. And so we'll be looking at these three areas and how the law of evidence, the aim of it is essentially to protect against these problems which have happened in our criminal justice system, including some of the biggest miscarriages of justice in our legal history, such as the post office scandal, to name just a few. But anyway, that now concludes this episode of my introduction to the Law of Evidence Revision podcast series. So I hope you've enjoyed this episode, and I look forward to seeing you in my next episode, and I hope you look forward to listening to my next episode as well. Please do send me a comment below. It's always great to hear from you, and I will always try my best to respond to all comments. And at the time of recording this podcast, my success rate is currently 100%, which is absolutely amazing. Please do also follow this podcast. It really shows me that you are enjoying this content, you want more of this content, and that really motivates me to provide you with more of this content. But also, please do leave a review wherever you listen to your podcasts, as not only, again, that shows me where I can improve it and really motivates me to continue these podcasts, but also helps others to find me as well. And so that can really help many people. And then, podcast side, also please go to my YouTube channel, Law with Charlie. Watch my videos, like them. Again, comment, because I love to engage with my audience. And again, subscribe. Please do subscribe so you don't miss any content from me ever again. I've got lots of different ideas for content which are coming up, and so trust me, you really do not want to miss them. But that's essentially everything from me for now, and so I hope you've enjoyed this episode. I hope you're going to be looking at my other content. Please do be in touch, and I look forward to speaking to you again on my podcast or even in my YouTube videos very soon. Goodbye.
Thank you for listening to Law with Charlie, with your host, Charlie Medcalf. Please do ensure that you leave a comment below, either to just say hello or ask a question. And please like, subscribe, and leave a review for more content like this. See you next time.